this whole thing features an interview with former special counsel for the U.S. Department of Justice, Jack Smith, discussing several topics related to investigations and potential legal proceedings involving Donald Trump. Take a listen to what Jack Smith has to say here.
A counterpoint to that, if Woodward has a bunch of cases before your office and he's representing a bunch of people, he may have felt threatened, but he also may have felt that it was in his strategic advantage to just try to forget about it because he doesn't want to make an enemy of Jay Bratt. Isn't that a fair counterpoint?
I don't think so, based on the number of interactions we'd had with him, and also the fact that he didn't even bring it up. Someone else brought it up, and when he was, again, I was told when he was confronted with it, he was surprised someone brought it up, made a reference of, I know how to make a complaint if I need to. That was my recollection. And then when he did make the complaint, he didn't just say, I think this should be referred to OPR. He said, and maybe in this letter, that yes, I think that this, let me make sure I get the language correct. Yes. We respectfully suggest that this matter be referred to the Department's Office of Professional Responsibility for a thorough investigation, and that any indictment arising from this investigation not lie until such an assessment is reached, knowing, as we do, that an OPR investigation can take many, many months. So that's my take on what happened, and I think our office responded appropriately to this. I don't credit it, but at the same time, we referred it to OPR so they could look into it.
Smith, he addresses allegations that his prosecutors threatened defense attorneys. He states that he has no evidence of such threats and would not condone them, indicating that any prosecutor under his supervision who engaged in such behavior would no longer be working with him. He also expresses skepticism that an experienced prosecutor would make such threats, especially in front of others.
It happened the way Mr. Woodward or Mr. Brand say it did. You would have an issue with that then. Is that fair?
I have no evidence that any of my prosecutors threatened defense attorneys. If prosecutors under my supervision threatened defense attorneys, they wouldn't be working with me any longer.
Okay. Woodward here is talking about essentially a veiled threat that he believes Bratt was mentioning this off the cuff to try to get him to play ball with NARA's cooperation. So if that had happened, you certainly wouldn't condone that, would you?
I would not condone anyone threatening a defense attorney, but I also say that if you've practiced law and practiced criminal law, that's just not something that would work. That's not something that I've seen an experienced prosecutor do, and to do it in front of several other prosecutors. It just, in addition to, for all the reasons I said I didn't credit it, I also think it just doesn't make a lot of sense. But to your point, if unlike this situation, a lawyer who worked under me threatened a defense attorney, yes, that would be inappropriate.
During the last hour, turning the page to a different topic, you said that you had not yet considered a sentencing recommendation had President Trump been found guilty in either one of the cases. Do you think that you would have recommended? You think you would have recommended a jail sentence, prison sentence, if he was convicted?
I'm not going to speculate on that because that would require a very detailed analysis of the sentencing guidelines factors, of what he was convicted of any mitigating factors. That's not something you do off the cuff, whether someone should be incarcerated or not, or how long. That's not something I would do without significant analysis.
And had your office undertaken any type of analysis on that front?
In terms of a thorough analysis, I don't recall anything like that. I'm sure that we knew how much the sentence could be in each individual thing, but I certainly had not turned to thinking about what sentences should be. As a rule, I don't do that until there's a conviction in a case.
Okay, so this is very, very interesting. So as he just mentioned, he states that he had not considered a sentencing recommendation for Donald Trump in either case. Had he been found guilty, means Donald Trump, he explains, Smith, that such a recommendation would require a very detailed analysis of sentencing guidelines, mitigating factors, and other elements, which is not something done off the cuff, quote unquote, or before a conviction. So we have just heard what he said. Now, Smith discusses the evaluation of Cassidy Hutchinson's claims, particularly regarding President Trump's alleged attempt to take control of a Secret Service vehicle and claims about Trump being informed of armed individuals at the January 6th rally. Take a listen.
But what would have the sentence have been for the charges that you indicted for?
I'm not going to speculate. I mean, if we sat down and went over the sentencing guidelines, we could talk about what that would be, but I have not done that analysis, and I haven't thought about that issue.
Would that analysis have yielded some jail time or recommendation for some jail time?
Again, I'm not going to speculate on that because, as I mentioned earlier, you only get to that if you try your case and you prove it beyond a reasonable doubt. We did not do that in this case. There was no trial, and we didn't do that.
He clarifies that Hutchinson's testimony was often second-hand or third-hand, and that direct witnesses, including the officer in the car, provided different accounts. Jack Smith, he also mentions that Hutchinson's testimony presented some inconsistencies, such as her handwriting not matching a note she claimed to have written. Take a listen a little bit more here.
The individual who worked for Mark Meadows by the name of Cassidy Hutchison was she was a star witness for the January 6th committee proceedings, and she made some real outlandish claims that, for example, one of them was that President Trump tried to take control of the wheel of the Suburban that he was being driven in. Is that an allegation that you're familiar with?
The circumstances regarding President Trump getting in the Secret Service vehicle after the alleged speech, yes, I am.
Okay. And what did your offices, did you evaluate that claim?
We did.
Okay. And what was your determination?
Ms. Hutchinson, regarding that particular claim, was a second or even third-hand witness. She had heard other people talk about that.
Okay.
And so we went to, we interviewed, I think, the people she talked to, and then we also interviewed, if my recollection is correct, officers who were there, and including the officer who was in the car.
Right.
That officer, if my recollection is correct, and I want to make sure I'm right about this, said that President Trump was very angry and wanted to go to the Capitol, but the version of events that he explained was not the same as what Cassidy Hutchinson said she heard from somebody secondhand. That's correct.
Debanking allegations. Smith is questioned about allegations that individuals associated with Donald Trump's inner circle were debanked, told to find a different bank. As a result of the investigation, Smith states that he has no knowledge of such communications between his office and banks, and that the term debanking was new to him until mentioned by counsel preparing for their interview. What you have heard from Jack Smith so far is very, very interesting. We will have to wait and see what happens, but the video title basically said that Jack Smith asked, would you recommend a jail sentence for Trump if he was found guilty? Now, we will have to wait for more hearing from him. Subscribe for more videos.